everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others, including my own misfortunes. If you're enjoying this channel, please remember to like, subscribe, and all that good stuff. For today's live content, we are doing a redo of yesterday's live content. This is the story of Amyiah Cohoon, the judgment. And yours truly made some fairly serious legal errors. And I noticed it immediately after the stream was done. I always watch my content back right away, and I noticed it immediately. I made a pinned post about it, say there's a correction here, but I strive first and foremost to be a good legal educator. And the video had such a glaring hole in it that I figured I had to redo it. It was not just something that I could blow off or do a short about. I figured it just had to be redone completely. So my end conclusion is going to be the same, but the analysis along the way has to change, and we strive for accuracy where we can. Okay, let's do that. So we're going to be discussing this judgment, and we'll discuss it as it goes along, so let's do this. Professor Chaos gives me 199, says, lol, I was just watching the playback of that one. Yeah, well, it needs help. The SARS-CoV virus and COVID-19 have had tremendous impact on American society. But as this case makes clear, that impact has its limits, and more specifically does not extend to overriding protections of the First Amendment. On April the 16th of 2020, teenage plaintiff Amyiah Cohoon, by and through her parents, sued the sheriff and the sergeant who violated her First and 14th Amendment rights when the sergeant, Clump, at the sheriff's direction, demanded that Amyiah remove a social media post detailing her recent hospitalization with COVID-19 symptoms. This is the early days of COVID. It's late February, early March. At the time, there is no confirmed cases of COVID in the entire county. So there's that. And she's saying I had COVID. Or at least, yeah, she's saying I had COVID. As a remedy, Amyiah seeks declaratory and injunctive relief, including an order barring defendants from threatening or taking coercive action against her if she posts on social media in the future about her scare with COVID. On April the 24th, defendants moved for summary judgment, and on May the 15th, Amyiah moved for summary judgment. The parties agree that the facts are not in dispute. There does seem to be pretty wide agreement of the facts. The entirety of Sergeant Clump's encounter with Amyiah and her parents is captured in a dashcam video. That video, along with other record evidence, establishes that defendants violated Amyiah's free speech rights by demanding she take down her social media posts or face criminal citation or arrest for disorderly conduct. Accordingly, Amyiah is entitled to summary judgment on a declaratory judgment claim, and for the same reasons, the defendant's summary judgment should be denied. The court will deny the request for injunctive relief. Her counsel conceded declaratory judgment would be sufficient, which, you can pretty much stop reading there. And the injunction she requests is premised on speculative and ill-defined assertions about what she might post in the future and what defendants might do in response, making injunctive relief inappropriate. So injunctive relief here would be an injunction against the police, and those are always problematic at best because you need the police to be able to lawfully enforce the law. So it's very difficult, if borderline impossible, to craft a injunction that's going to do what it needs to do. So it's no surprise to me that the court bounced it. And also they said that the declaratory relief would be enough, so it's not surprising. All right, so let's review some facts about what happened. In March of 2020, Amyiah, then a sophomore in high school, traveled with her school band on a spring trip to Disney and Universal Studios. It was a band trip, as I understand it. During the trip, various states, including Florida and Wisconsin, declared public health emergencies in response to the then just emerging COVID-19 pandemic. It was brand new at that time. Yeah. 4 days after returning home from Florida, Amyiah began feeling ill. Her symptoms included a fever and dry cough. 2 days later, she had trouble breathing, so her mother took her to the emergency room at Divine Savor Hospital in Portage, Wisconsin. The doctor at Divine evaluated Amyiah and diagnosed her with acute upper respiratory infection. They informed her that the symptoms were consistent with COVID-19, but they said they could not test her for the virus due to testing criteria in effect at the time. So for those of you who may not remember, in the very early days of COVID, testing kits were hard to come by. And so the testing kits were usually reserved for medical personnel and things of that nature. They were not really available on a patient-by-patient basis in the early days of COVID. Also because the tests, may not have been the greatest. Obviously, we came up with better tests as we learned more about the virus. So, yeah. So she wasn't given a COVID test at this initial hospital because COVID tests were hard to come by. They then discharged her with an inhaler and instructions to strictly self-quarantine for 14 days and return if her condition worsened. They also instructed her parents to self-quarantine for 14 days, consistent with COVID protocols at the time. After returning home, Amyiah posted about her experience on Instagram, captioning a photo of herself from the spring break trip with, "Hey guys, sorry I've been on a long break. I won't be back for a while longer due to me now having the COVID-19 virus. I don't want the attention, it's just the truth. I'm now in self-quarantine and not allowed to leave my room and have an inhaler since they said go home. Best wishes, love you guys." So, yeah. So they have told her that she has symptoms consistent with COVID-19. The doctors have. They haven't tested her for COVID, but they've told her that they have symptoms consistent with it. And so to, quarantine yourself. So she says, I have COVID, which is pretty much what the doctor said, all but. And I have to quarantine, and I don't want attention. I'm just telling you because that's what reality is. Okay, so that's the first Instagram post. 3 days later, on March the 25th of 2020, Amyiah's symptoms worsened. Her mother promptly took her back to Divine Saver, which redirected her via ambulance to University of Wisconsin's Children's Hospital, which apparently had better facilities to deal with this. Once admitted to the Children's Hospital, Amyiah was finally tested for COVID. Her test came back negative the following morning, but doctors told Cohoon that she still might have COVID-19 and simply missed the window for testing positive. To that end, they released her with orders to continue her 14-day quarantine. So, yes, the second hospital has done a COVID test. The COVID test has come back negative. That might be because of the quality of the test at the time. It might just because it's a straight-up false negative. Whatever. But they say, yeah, we think you have COVID-19. We don't believe the test. Which, fair enough. The test is not God. The doctor's closer. So the doctor's like, yeah, we're pretty sure about the COVID-19. So continue with the isolation despite the negative test. But critically, as part of our analysis as we go on, there was a negative test for COVID. So let's press on with the analysis. After arriving home from the hospital, Amyiah again took to Instagram. She posted a photo of herself with an oxygen mask on her face, caption, "I'm finally home after being hospitalized for a day and a half. I'm still on the breathing treatment, but have beaten the coronavirus. Stay home and be safe." Which is the thumbnail of this entire series, because we need to bring what we're talking about to light. At the time of the post, Marquette County, Wisconsin, had yet to register even a single confirmed positive COVID case. It was early days of COVID, right? So one of the things we have to keep in mind as we're evaluating this, right? We have to evaluate things at the time when we're considering people's decisions and what they're doing, right? What information did they have? What information didn't they have? So putting ourselves in the time and the place and the knowledge that's available is important. That's why I keep mentioning it. Early days of COVID. So in the early days of COVID, there wasn't a lot of testing available. A lot about COVID was an unknown. That we didn't know how serious this was. That we didn't really understand its likely impact. We didn't really understand if it was the flu or the plague or somewhere in between, right? It was a novel coronavirus. Amazingly, we didn't know a lot about it at the time. So people were concerned about it because, not sure where on that continuum we are. So the flu or the bubonic plague? We're not sure yet. Okay. In the hopes of convincing Amyiah to voluntarily remove the post, the county health department referred the matter to the sheriff. Now, the county health commissioner is in just a good position to contact Amyiah as the sheriff is. I mean, she has her contact information. She could go herself and ask, but she can't be bothered. So she's going to get the police involved. Yeah. In response to in hopes of convincing to voluntarily remove, we get someone who has the power to arrest you. The sheriff relayed the necessary information to Klump, who was on duty at the time. The content of the conversation was later summarized in Sergeant Klump's detailed incident report, which the sheriff reviewed and approved. The report states, Sheriff Conrath advised he wished for me to respond to the residents and have Amyiah's post removed from her social media. When I advised Mr. Cohoon that I was there to have Amyiah remove the post, he became upset. Yeah, so the sheriff has asked the deputy to go to the home and ask that the post be removed. Okay, that's the situation in the early days of COVID. So what does the officer know at the time that he's going to the house? That's helpful, right? Because we want to put ourselves in his shoes as we're evaluating things. So what does he know? He knows that there's been a negative test. That information's been shared with him by the county health commissioner, which appears to be perfectly legal. HIPAA doesn't cover everything, and this would be one of the things it doesn't appear to cover. So yeah, the health commissioner has said, no, that wasn't a confirmed case. It was a negative test. So the sheriff and the deputy know that. That's important as they're going up to the house. On the evening of March 27, 2020, Sergeant Klump arrived in Cohen's home. A microphone and dash camera captured audio and video of the ensuing interaction. We saw the audio and video together. We did a reaction to it as part of this series. Sergeant Klump spoke for some time with Mr. Cohoon before Mr. Cohoon and Amyiah joined them outside the house. It's probably Cohoon, but we'll go with Cohoon probably. Sergeant Klump said, all I'm here is to figure out what this post is about, seeing she tested negative, which he knew. That was a fact he knew. And we need to get it taken down. Amyiah then agreed to go inside and take the post down. Some other things happened that are important. While inside, Sergeant Klump threatened Mr. Cohoon. If the post doesn't come down, the sheriff has directed me to issue disorderly conduct citations, if not start taking people to jail. So it appears, based on the information that is pretty much uncontested, because it's uncontested, it is uncontested that there was no direct threat of arrest to Amyiah before she removed the post. Everyone has agreed to this. And the threat came after to arrest. So one of the parts of the court's analysis is going to be whether or not this threat could have influenced Amyiah, because she didn't hear about it before she removed the post. So, how could it? The court will analyze and we'll discuss. After removing the post, Amyiah exited the house again, and so the sergeant her Instagram page. While outside, Amyiah heard her father twice repeat Sergeant Klump's earlier threat. You guys want to threaten someone with going to jail over it and add insult to injury. So now Amyiah knows about it. And it doesn't do any good when you can't warn people when you got a sheriff's department threatening to throw people in jail over it. Amyiah now is aware. Sergeant Klump did not correct Mr. Cohen's recitation of the threat, instead saying, I'm just doing what we can do as a sheriff's office, okay? Well, whether or not it's okay or not will be part of our analysis. As the sergeant departed, Amyiah also deleted her March 22nd Instagram post about her first trip to Divine Savior. Later that evening, the Cohens discovered that the school district superintendent had sent a news updates to families in the district that included a statement about Amyiah's post. The superintendent has some thoughts to say. The update from the superintendent said, it was brought to my attention today that there's a rumor floating out there. One of our students contracted COVID-19 while on a band trip to Florida 2 weeks ago. Let me assure you there's no truth to this. This was a foolish means to get attention, and the source of the rumor has been addressed. Amyiah has not posted about her experience with COVID-19 on social media since. Okay, there are a couple facts that are missing from the court's recitation of the facts. And we know this because we've read all the pleadings up to date. So there's an additional factor that should be considered that the court isn't mentioning. And the fact they're not mentioning it kind of somewhat suggests they don't want to mention it because it kind of belies their analysis. So it suggests maybe the court isn't mentioning it because it would undercut them. The part of the analysis, the part of the facts they're not mentioning is that Amyiah had called her band teacher, because it was a band trip, to inform them. And I believe it was Amyiah's mother who called the principal to advise them. Also, at the time, there was a bit of a panic going on, which the court isn't mentioning. The school district, the principal, probably the superintendent for all I know, but definitely the principal and the band teacher for sure. Those were in the facts. The county health commissioner, that was in the facts too. They're suddenly getting lots and lots of calls from lots and lots of panicky people who are now wondering whether or not they might have COVID, right? Because Amyiah, who's part of this band trip, just said, I have COVID. Everyone kind of freaks out a little bit, which is understandable because, again, novel coronavirus, early in stages. We don't know anything about this thing. All right. So there was, in fact, in reality, a bit of disquiet, and it was causing at least some inconvenience and some panic that was notable. And that is a relevant factor in this analysis, one way or another, but the court isn't mentioning it because it would somewhat undercut their analysis. It would be my conclusion. In her complaint, Amyiah alleges defendants violated her First and 14th Amendment rights when sheriff sent the sergeant to her home and coerced her into taking down social media posts. She seeks two remedies: declaratory judgment and injunction. The court will grant the first relief but deny the second. Okay. So we are here on a declaratory judgment case. There's an act that's the Declaratory Judgment Act. Creatively named, right? And what a declaratory judgment is it allows the court to declare something to be true. All right, this is true. And it allows them to declare that someone's rights have been violated, for example. So Amyiah has asked for this declaratory relief. She asked for nominal damages in her complaint, but she's not really asking for money. She's asking for the declaratory relief. She wants the vindication of being right, retrospectively, from a court. That's basically what she's asking for. Now, a court can do that if her rights were violated. But, we have to figure out if that's true. We know that she posted some things on Instagram. She believed them to be true for good reasons. Her motivations may have been very pure indeed to share them with others. So we know that from Amyiah's point of view. We also know from the other from the point of view of other students and other parents, they're kind of panicky. We also know from the point of view of the sheriff and the deputy that there's no confirmed COVID cases. Right? It's important to keep all these perspectives in mind as we're jumping around, trying to look at how different people are looking at the situation at this point in time to understand their decision-making. Plaintiff is entitled to declaratory judgment on our First Amendment retaliation claim. All right, so I'll state what I stated before in the earlier stream, what I got wrong, but I'll state it again because it needs to be clear, right? I'm going to give you my legal analysis. It's going to disagree with the court in parts. That isn't because I necessarily think that what I'm saying is good in some sort of moral level, but I'm going to tell you law as best as I can understand it. District courts sometimes get the law wrong. This might be one of those times. I don't know if anyone will appeal this or not, but, the district court has an opinion. It can be wrong. District courts get reversed. For that matter, courts of appeal get reversed. And sometimes the Supreme Court says things and we don't really believe it either, but it is the final step in the chain, but, whatever. So I'll give you my best legal analysis regardless of my personal opinion. Okay, so let's do that. The Declaratory Judgment Act, which is not 42 U.S.C. 1983, grumble to myself, empowers the court to declare the rights and other legal relations of any interested party when there's a case in controversy within its jurisdiction. To establish case or controversy, the plaintiff must prove that they suffered an injury in fact, is fairly traceable to the challenged conduct, and that they can be redressed. So I was hurt, they did it, the court can do something about it. Okay. To establish injury in fact under the First Amendment, a plaintiff may show chilling effect on speech that is objectively reasonable, and self-censors as a result. Amyiah alleges that she removed her Instagram posts and has continued to self-censor since her encounter with the sergeant. She also contends that she fears posting about COVID-19 again because it might subject her or her parents to citation or arrest under the Sheriff's Department's broad reading of the disorderly conduct statute. Yeah, we'll get to that. The disorderly conduct statute has an and other stuff provision, so we'll get to that in due course. But whether or not they're too broadly reading it, well, that's a legal opinion, right? So we'll provide ours. She also contends we read that Amyiah's posts were silent as a result of defendant's conduct, allegedly in violation of the First Amendment, establishes injury in fact. Okay. Yeah. That makes sense. Further, the Seventh Circuit has held that Amyiah's assumed fear of future sanctions is itself objectively reasonable. It is. You know, when you're looking at this, you usually look at it from the view of a reasonably prudent person, although you might modify that slightly in the case of a juvenile, because they're not expected to necessarily be the reasonably prudent person. They have freedom of speech rights too. But either way, it doesn't really matter because this would be objectively reasonable. I'm going to arrest you if I don't. You know, it doesn't get much more objectively reasonable than that. So, yeah. Not a lot of analysis on that one. There is no dispute that the injuries are the direct result of, and thus fairly traceable to the defendant's conduct. It's definitely traceable to it, that's for sure. She took down social media posts only after the sergeant's visit to her home. And because the chilling effect on her protected speech is injury, and that chilling effect persists to this day, is likely to be redressable from a favorable judicial decision. The court can do something about it, that's true. Whether or not they should do something about it as a matter of law, yeah, but they can. Thus, the plaintiff has met standing. Yeah, I have no problem with standing. Standing's easy. Standing's easy. A government official has directed me, forced me, compelled me to take down my post. I mean, that's pretty direct. You know, they did a thing to me. Standing is not an issue. I think we can all get behind that. The record establishes all the elements of a First Amendment retaliation claim, but does it though? As a general matter, the First Amendment prohibits government officials from subjecting an individual to retaliatory actions, including criminal prosecutions for speaking out. The critical words in that sentence would be "as a general matter." And in specific matters, you know, maybe not. To prevail on First Amendment retaliation claims, the plaintiff must show three things. First, they must show that they engaged in protected First Amendment activity. Second, they must show the adverse action was taken against her. Third, they must show that her protected conduct was at least a motivating factor. Here, they satisfied all three elements. Yeah, so I'm a little bit dubious on a matter of law. I'm dubious, but we're going to be reading this again. Maybe the court will convince me the second time. But I'm a little bit dubious on point one. But we'll see what we think. Even if short and often grammatically scurrilous, social media posts do not fall outside the ambit of the First Amendment. This is absolutely true. The First Amendment absolutely protects social media posts just as much or just as little as billboards or newspapers or conversations in your local cafe. Yeah, the First Amendment applies here, no problem. To the contrary, they are exactly what the First Amendment seeks to protect, at least in part. In the eyes of the law, when Amyiah took to Instagram, she is no different than John Tinker wearing a black armband in the halls of De Monte Public Schools, or Paul Roberts Cohen's famous "fuck the draft" jacket wearing it in the corridors of the Los Angeles courthouse. And her speech deserves the same degree of attention. See, for example, Tinker and Cohen. Those are great examples, yeah. So there is a bit of a principle difference. There is a bit of a principle difference, at least possibly. right? In the case of Tinker, the guy, was wearing a black armband. The black armband was understood by everyone who was wearing it to mean Vietnam is bad. That was what the black armband. Vietnam, bad. War in Vietnam, bad. Specifically, the war in Vietnam, not the country necessarily. War in Vietnam, bad. That's what it said, right? That's an expression of opinion. In the case of Cohoon versus California, the the draft jacket, I mean, that's an expression of an opinion too. Those are valid opinions. They can't be proven true or false. You can't prove objectively that that's true or false. People have a variety of opinions about them. So here it might be partially different because Amyiah isn't necessarily expressing her opinion. She's expressing a purported fact that she has and has recovered from COVID-19. Now, that was what the doctor told her. The doctor had reasons to believe it. That was the doctor's opinion. But once the doctor states an opinion, we're treating it as a factual claim because he's an expert, right? So we're treating it kind of as a factual claim. It's not just a pure opinion like I like roses. Like I like roses is an opinion. You have COVID is not in the same category. I think we can agree to that much. So the doctor has told her that. She's expressing a statement of fact. This statement of fact has a possibility of implicating might not be the right word. It would have the possibility of reaching out to other people beyond her because it is a contagious disease of unknown threat at the time, early days of COVID, right? So she is saying, I had COVID from her hospital bed, taking the pictures. Okay. And people, understandably, are concerned about this. There has been many a phone call given with people worried about this. So there is, in fact, some disruption. So I think the analogy from the court is slightly off point because Amyiah isn't expressing an opinion, or at least not a pure opinion. She's representing facts. Facts, incidentally, that the sheriff's office has reason to believe is false because of the false negative test. So the sheriff isn't exactly coming out of nowhere with his belief in the falsity of it. Okay. The analogy might be roughly equivalent. The analogy might be roughly equivalent to a person shouting fire in a crowded theater. Now, that's not a statement of opinion. That's a fact. Fire. That's a pure fact, right? Now, we all know from our coverage that you can shout fire in a crowded theater if it's in fact on fire. But the sergeant has heard from the county health authority, which, is pretty high up, that there's a negative test. So this would be the rough equivalent. This would be the rough equivalent of a person shouting fire in a crowded theater. There is in fact a fire, but the fire marshal, who also happens to be there at the time, says there's no fire, there's no evidence of fire, these are lies, and the police arresting you for the panic. Because even though it was true, the competent authority, namely the fire marshal, who may or may not be competent in his job at this moment, but whatever, the competent authority has said, oh, this is not true. So that would be the rough analogy, right? Shouting fire in a crowd theater, there is in fact a fire, but the fire marshal says there's not, and the police arrest you. That would be closer to where we are. Defendants disagree. In their view, Amyiah forfeited her constitutional protection when she published a post that caused concern in the community and led to an influx of phone calls to the Westfield School District and Marquette County Health Department. Okay, so we're looking at this from a position of disorderly conduct, right? I think we can agree disorderly conduct is probably not legal. I mean, every city, state has disorderly conduct charges. It's definitely possible to be disorderly conduct. What does disorderly conduct look like? Well, generally speaking, it looks like causing a disruption to everyone else's good time. It's the person shouting loudly in the coffee shop when, no one else wants that. It's disrupting everyone else's good time. So it can be that. It can be merely irritating. That's enough. Or it can be something that induces a real panic, like there's a chemical spill. We all need to run for our lives. If it's not true, or Again, in this analogy, it is true, but the chemical inspectors somehow say, no, there's no chemical spill, despite, the chemical spill, but we'll put us past that. That might be causing a disorderly conduct, and the police might be able to act accordingly. So that's kind of the thing we're thinking about. According to the sheriff, this was akin to shouting fire in a crowded movie theater. Yes, and in this increasingly weird analogy, that was on fire, but the fire marshal says isn't on fire. That's basically where we are. Defendant's argument still fails. While content-based speech restrictions are permissible, in limited circumstances, such as incitement, obscenity, defamation, fighting words, child pornography, and so forth, the Supreme Court has rejected as startling and dangerous a free-floating test on the First Amendment. This is true. We need a little bit more than startling or dangerous for the First Amendment. First Amendment does protect things that are startling. We need something more than that. Labeling censorship societally beneficial does not render it lawful. True. If it did, nearly all censorship would evade First Amendment scrutiny. Not sure about that, but perhaps much would. Defendants may have preferred to keep Marquette County residents ignorant of the possibility of COVID-19 in their community for a while longer. Well, I don't know that that's a fair characterization of what Marquette County was trying to do. I don't know for a fact, but because it's not on the record, but you're assuming motivations here. I don't know what Marquette County, Wisconsin was doing in early March 2020, but they might have wanted people to be aware of this new COVID virus. But that's a far different thing from we have a case, right? We want you to be aware of the threat versus the threat. It's the difference between a tornado warning and a tornado watch, right? And, there's a difference there. They might want you to be aware of it. So I don't know that's a fair characterization of the motivations of the county health commissioner here. But that preference does not give them authority to hunt down and eradicate inconvenient Instagram posts. Again, it's not merely that it's inconvenient. It's not merely that it's contradicting the facts, right? That's not enough. But the fact that it is causing a real world harm is part of what disorderly conduct looks like. I mean, people are in fact, the order has become disordered for what everyone except for Amyiah and her family and her doctors, but everyone else believes is a lie. For valid reasons, they believe it's a lie. The negative test, right? So, yeah. Amyiah's post is not captured by any of the categorical exceptions to the First Amendment, so the court will not balance the social utility of curtailing it against government assigned value. Yeah, but this seems a little bit off because it would imply by the court's reasoning that, disorderly conduct charges are not proper in any instance, which doesn't seem correct. But defendants persist. They cast Amyiah's characterization of her illness as a lie, which is what people believed at the time. Although, to be fair, the defendants are going about this the wrong way. They're going about the wrong way. They should focus on what they knew at the time, not like cast aspersions back. Right? This is what we knew, this is what we didn't know. Versus here's what we think now. So the defendants kind of go too far in their case. They cast Amyiah's characterization of her illness as a lie, insisting that because she ultimately tested negative, she was prohibited from publicly proclaiming she had been COVID-19. Yeah, I think they're trying to make that statement like now, so that she's still lying. Which, you didn't need to make that argument. It's completely unnecessary and makes you look kind of jerkish. But the very doctors who tested her informed her she may have had COVID-19 by the test. Yeah, tests are helpful. Tests are helpful. And sometimes doctors say, you know what? I don't believe that test. I think that test is lying. Because, that's one of the reasons they have lots of education. And they can be like, not so sure about that one. Test. Yeah. Her Instagram post, therefore, was at worst incomplete. The notion that the long arm of the garment, redaction pen in hand, can extend to the sort of incomplete speech is plainly wrong. That's not the problem. The problem isn't that it's incomplete. The court is mischaracterizing the nature of the problem. right? They're putting words in the defendant's mouth. Not that they help themselves along the way too much, but they're saying, oh, the problem is it's incomplete and you can't use the censorship pen because of incomplete. Yeah, that's not exactly the argument. The argument is more about, the panic and disruption it was causing at the time. That's the argument. So they're kind of straw manning the argument here, it seems to me. The Marquette County Sheriff's Department had no more ability to silence Amyiah's post than it would have to silence the many talking heads on cable news who routinely pronounce one-sided hot takes on issues of the day, purposefully ignoring any inconvenient facts that might disrupt their narratives. The example is a bit off point. Talking heads are usually expressing opinions. That's kind of what they do. To the extent that they're presenting facts, they're usually true, but there's other facts they might be ignoring, but, that's part of the debate, right? What facts do you think are important and not? But yeah, the example's a little bit off point. Also, the example's off point because usually when the talking heads are talking about things, even where they're facts, they're kind of well-established things. They're not usually talking about like novel things that have never been seen before. So your average political pundit, when they go on the news and they talk, even if they're representing facts, these are facts, even if the facts themselves are new. They're of a kind that are known. So people have a baseline to understand them that they might not necessarily have in other contexts. That doesn't necessarily mean that they're harmless, by the way, because if a broadcaster is knowingly telling lies, especially about another person, that can be defamation. And it might be some other things too. So the example's a little bit off point because, talking, and even in the early days of COVID, they were expressing a lot of concern about COVID and what it might be, but they weren't saying things like, I had COVID, when there were negative tests, right? That the example is a little bit off point to go to where the court's trying to go. The government here had every opportunity to counter Amyiah's speech, but instead opted to engage in an objectionable practice of censorship. I don't necessarily know. Maybe that's enough. Maybe that's enough for the county to go forward and just say, there's a negative test result. We have no evidence to support this. Maybe that's enough to undo this. So the court might have a point there. But if there's truly disorderly conduct, it's not necessarily true. The government's ability to have messaging of their own can undo the disorderly conduct that's occurring. All right. It might in some sense counter it, but it doesn't stop it. Right. And disorderly conduct, to the extent it is a violation of law, is a violation of law. Right. So the government's ability to speak out against it doesn't solve the underlying violation to the extent it exists. So that's a little bit off in my view. Because her Instagram post was undoubtedly protected by the First Amendment, the court finds Amyiah has satisfied the first element. Yeah, I'm a little bit. Yeah. Amyiah is saying what she believes to be true. So this is interesting because it's a very weird situation. And also the fact that the First Amendment protects lies, so it doesn't have to be true, is also a factor here. So Amyiah is expressing something that is in fact true from her point of view, and she's sharing it with perhaps good motives in mind. But this true information is causing a real panic. You see, it's having an actual impact among people, and for like good reasons, right? It's not Karen who's having a problem. Karen can stuff it. It's the public at large that are having a problem, and they're having a problem for a fairly good reason. That this is a novel virus, and they probably need to do something about it, or they should have concerns about it. So Amyiah's speech, is it protected by the First Amendment or not, is an interesting question, because from Amyiah's point of view, yeah, but from literally everyone else's point of view, except for, of course, the doctors and her parents, no, because, it's actually in reality causing an induced panic among people for good reasons, for objectively good reasons. And the county has objectively good reasons to believe it's wrong. So I'm not so sure about point one of the analysis. The court might have it right, but I'm a little bit dubious. I'm also a little bit dubious in part because some of their reasoning seems a little off to my mind. And because they left out some things and the way the court summarized things, it seems a little unfair. Seems a little strawmanny. So I'm not completely sold on point one. They might be right, but I'm not 100% sure. Defendants took adverse action against the plaintiff. The standard for determining whether an action is sufficiently adverse to constitute retaliation is well established. It must be likely to deter a person of ordinary fitness from continuing. Yeah, again, not the least common denominator, the reasonably prudent person. The ordinary man test. The ordinary person of fitness. Would it deter a normal person who's not, crazy? The Supreme Court has often noticed a realistic threat of arrest is enough to chill First Amendment rights. It sure is. This realistic threat of arrest establishes adverse action for retaliation purposes. The audiovisual recording of the police encounter at the home captured Sergeant Clumps threatening Mr. Cohoon. If the post does not come down, the sheriff has directed me to issue disorderly conduct citations, if not start taking people to jail. That's pretty direct. According to the defendants, because Sergeant Clump never made this threat to Amyiah directly, instead uttering the threat only when her father was present, she could not personally have experienced any threat of adverse action. Well, to the extent she removed the post, maybe, but to the extent she's being silenced in the future, no, because she knows that information. It's been shared with her. According to the defense, the superficial analysis fails for a number of reasons. First, the record made clear that Sergeant Clump's intention throughout the 30-minute visit was to get Amyiah to remove her social media posts through use of threats up against her and perhaps her parents. I agree with the court. I think the last statement from the sergeant reasonably informs the entire tenor of the conversation, right? If we were looking for ambiguity, right, trying to figure out the ambiguity, the statement at the very end can reasonably inform everything that was said before. Like, that was my motive the whole time. So that's a very fair conclusion from the court. That he expressed this intent only during discussions with the father after Amyiah retreated in the home does not mean she was not the realistic threat of the threatened action. Indeed, it appears Amyiah made the logical hop necessary to infer the sergeant had threatened her arrest because in her sworn declaration she recalled, after the sergeant left, I was afraid that he would find my first post and come back for me for that one, so I deleted that post too. Moreover, she stated, I'd also like to post further about my scare with COVID-19 and to repost the posts I removed, but I'm afraid that another officer will come to my home and cite my parents or me. Yeah, this is definitely a reasonable fear in the future. I agree with Amyiah's concern. So not only was Sergeant Clump's threat of arrest likely to deter a person of ordinary fitness, but also it did in fact do that. Yeah. If she was not in fact deterred, then it wouldn't matter, right? Further in the video, the interaction shows the police officer twice in Amyiah's presence declining to contradict the assertions that the sheriff's department was threatening to take them to jail. Yeah, that's also what he told him, so yeah. This was a very real threat of arrest, both to a person of ordinary fitness, yes, and particularly a 16-year-old child watching a policeman argue with her father over the exercise of her own free speech rights. I concur. Analogizing a citizen's ability to consent to warrantless police searches of their property. Defendants argue Amyiah's decision to acquiesce in deleting her posts rendered the action voluntary. No, that's a loser. That's a complete loser. Defendants correctly allude to the important difference between government expression and intimidation. The first, which is prohibited by the First Amendment, the latter forbidden. The government trying to persuade you is one thing. The government forcing you is different. In the First Amendment retaliation context, what matters is the distinction between attempts to convince and attempts to coerce. The defendants asked the court to lump Sergeant Clump's efforts into attempts to convince. Amyiah agreed to delete her Instagram post prior to learning of Sergeant Clump's threat. How then, defense asked, can she possibly claim coercion? Yeah. The argument ignores the inherently chilling and coercive effect of a uniformed police officer showing up at the teenager's home and demanding she cease the otherwise protected speech. This is so true and so annoying. Any number of people could have gone and probably convinced her, to be quite honest. I mean, if I had to hazard a guess, maybe I think her band teacher might have had a half decent chance at it. School principal, the county health commissioner, I don't know. I think there's a half decent chance that Maya might have been convinced by any of these people. The fact that we resorted to a person with, a gun is a bit weird. Why didn't we try something else first? Sergeant Clump's dashcam footage shows it was not persuasive rhetoric that led it to deletion, but rather her demands under the auspices of the Sheriff's Department. We need to get it taken down. That's coercive by any metric. I concur. The state cannot dispatch law enforcement to the home of a teenager to demand she remove any Instagram post that government officials disagree with, which again, is a mischaracterization by the district court. Right? I highlight these things to you because it's like, this is a mischaracterization, this is mischaracterization, here's a whole bunch of facts the court left out because it shows weaknesses in the argument, right? It shows the court's a little straw manning because maybe the court doesn't think it can really stand up on its own merits. So, like, why else did they exclude from the statement of facts all those things about all those calls? Why didn't they mention that? Why are they saying this, which is not quite correct? It's not that they merely disagreed with it. It's a little bit more than that. And then claim officials were only engaging in the Socratic method. It's possible that a Westfield administrator or McKitt County Health Department employee could have engaged in a mutually respectful discussion with Amyiah to try to convince her. But that's not the method they chose. Yeah, like, why didn't they? Yeah, or the principal or the band teacher or like any number of people who might have been able to make a pretty good try at it. They instead tried to rely on the coercive power of the sheriff, and any attempt to obfuscate that fact by casting it as an earnest public relations expert must fail. I agree. Because he's subjected to realistic threat of arrest, and in the future for that matter, Amyiah has satisfied the second element. I have no problem with the conclusion of the court's second prong analysis. I have problems with parts of their analysis, as I've highlighted. There's some issues here that seem to mischaracterize what is going on exactly. There's some things here that show some weaknesses of the opinion. The conclusion is right, the reasoning is a little off. The Third Amendment of the claim for retaliation under the First Amendment requires a plaintiff to show the adverse action was motivated by protected conduct. A motivating factor does not amount to a but-for factor or an only factor, but a factor. Any factor at all, right? We've got this down. It's not but-for, it's not like the majority factor, a factor. A motivation was a reason you were doing this. Yeah, that's. On this element, the defendants graciously carry a plaintiff's burden for them. Following the encounter, Sergeant Clump filed a detailed incident report that the sheriff reviewed and approved. Within the report, Sergeant Clump conceded. The sheriff advised that he wished for me to respond to the residents and have the post removed from social media. And when I advised Amyiah's father that I was there to have Amyiah remove the post, he became upset. By defendant's own admission, then, the entire purpose for the visit, and by extension, the motivations for the threat of arrest, was to achieve the removal of the protected speech, but see our analysis from Part 1, from the Instagram account. Here, the protected conduct was the only motivating factor, not that it matters. A factor will be fine. So Amyiah satisfied the third element. Yes, I agree. So I agree that Amyiah has our elements number 1. Apologize. I agree that Amyiah has elements number 2 and number 3. I'm not so sure about number 1. Yeah, I'm not sure if I 100% buy that. Under the law, as I understand it. Again, not necessarily what I think personally, but as my understanding of the law from reading as many cases as I have on my channel and other cases besides. Defendants argue that even if Amyiah can establish a First Amendment retaliation claim, her request for relief fails because they have probable cause to arrest under Wisconsin disorderly conduct statute, and they're entitled to qualified immunity. Both arguments fail. Okay, so we're going to deal with defense. The defense has two options, or two ideas. Probable cause to arrest, which also by law includes arguable cause to arrest. So probable cause or arguable probable cause, and qualified immunity. Now, as we've discussed before, probable cause is a fairly low standard. Reasonably articulable suspicion for like a Terry stop is even lower. It's probably 1 or maybe less than that, but probable cause does require a little bit more. So on a scale of 1 to 10, probable cause, it can't be a 5 because that would be preponderance of the evidence, and that's not right. So it has to be less than 5 by necessity. So the probable correct answer here is probably 2. Probably 2. Maybe 3, but yeah, something like that. On a scale of 1 to 10, it's not a lot. You just have to have, for probable cause, you have to have a reason that a person would believe that a crime is being committed by this person, right? You have to come into the possession of some evidence that would lead the reasonable officer, or for that matter, the reasonable person, would lead the reasonable person to believe an offense is being committed under the text of the statute as we understand it, right? So that's what probable cause looks like. Yeah, okay. So we'll do that analysis. Defendant's probable cause defense is based on Supreme Court holding in Neves versus Bartlett that a plaintiff bringing retaliatory arrest claim based on speech protected by the First Amendment must prove the absence of probable cause for arrest. So the U.S. Supreme Court has told us that if the police have probable cause or arguable probable cause to arrest, you can't bring a retaliatory free First Amendment claim, right? And that's what this entire claim is, a retaliatory First Amendment claim, right? So even if you buy all parts of an earlier analysis, 1, 2, 3, where we discussed what retaliatory First Amendment speech looks like, that was the entire point of covering that. So that's what you need. You need to have the right and it be motivated by it and harm. It's like, okay, even if you buy all that analysis, the Supreme Court has told us that if there's probable cause to arrest, you can't bring a retaliatory claim. So the question is there probable cause? Okay. The test for probable cause, as I've been saying, is objective, asking whether a reasonable officer, or for that matter, a reasonable person, would have believed the person has committed a crime. That's basically what I said. If so, the arrest is lawful even if the belief has been mistaken, right? So would an objective, reasonable officer believe that this crime has been committed even if the belief has been mistaken, right? That's kind of important because it very well may have been mistaken, but he couldn't have known that at the time, or there's certainly evidence against that at the time. Now, it is true that Amyiah and or her father told the sergeant when he arrived, they told him the doctor had diagnosed them with COVID, but there's no reason that he would necessarily believe them because, people say all kinds of crap to police. But what he knows for certain is what the medical authorities have told him, which is a negative test. So, yeah, they tried to tell him, and it's true, but there's just no reason for him to necessarily believe it. If police had to believe everything someone said, So, yeah, that's where we're sitting on that. Defendants insist that based on knowledge at the time of the encounter, that's important, Sergeant Klump had probable cause to arrest Amyiah under Wisconsin's and Marquette County's disorderly conduct provision. In relevant part, these prohibit the following. Whoever, in a public or private place, a private place would be, for example, a cafe shop, and a public space would be, for example, the park or something like that, or a street, engages in violent, abusive, indecent, profane, boisterous, unreasonably loud, or otherwise disorderly conduct, in which the conduct tends to cause or provoke a disturbance. All right, so there's a couple ways to analyze this that we should discuss about. The first is, we can usually follow the rule. There's always a good rule here that when a statute follows with "and other stuff," the "and other stuff" is to be understood of the like and kind of the stuff that preceded it. So What Amyiah did in reality is she created an Instagram post. This Instagram post, in fact, created a disruption, concern, panic in the relevant community, and was causing lots of calls to the administrators and to the police and to, well, not the police, but the health authority and to the principal and so forth and so on. So that's what Amyiah did in reality. That's what happened in reality. So let's see if that is either any of these things or anything like these things. So is it like violent conduct? No, it's definitely not that. Is it abusive conduct? No, abusive conduct would tend to imply that you're trying to harm someone else in some way. Indecent? No, it's not indecent. Profane? That's not the problem. Boisterous? No. Unreasonably loud? No. So one could take the position, and it would be a reasonable position, that the and other stuff should constrain based on the things that preceded it. And that would be a reasonable position. But that's a reasonable legal position, right? That would be like the end conclusion for a lawyer. That would be the end conclusion for a court. The question isn't necessarily what would a judge rule or what would a lawyer think. The question is the officer, and they're reading the statute, right? And so cops don't have a lot of legal training, except, where it's necessary, and definitely not on this, I presume. So when they see something like other disorderly conduct that in which the conduct tends to cause or provoke a disturbance, from the position of the reasonable officer at the time, reading this rule as it's written, a reasonable officer could very well come to the conclusion, particularly because they might not have legal experience on this aspect of law, but they might very well come to the conclusion that otherwise disorderly conduct, because it's in fact causing a disruption, it might fit into that. So that's a reasonable position for the officer to take, even if ultimately a court would construe it differently. When we're talking about probable cause arrest, we're not talking about whether or not the court would have dismissed the case for this reason. We're not talking about whether or not the prosecutor wouldn't have charged it for this reason. We're not talking about whether or not she would have been found not guilty for this reason. We're talking about the initial arrest, and that's all. So, yeah, the court might have come to that conclusion, but that doesn't matter for the position of the officer. The question is what the officer knew, not what some future court would have ruled in that case had it happened, right? Okay. Defendants appear to recognize that none of the state-specific enumerations even remotely apply. I had a hard time squeezing it in to the Instagram post, and thus focus on the otherwise disorderly conduct language. Wisconsin courts have interpreted this phrase to encompass acts that corrupt public morals or outrage the sense of public decency. Now, when they say that, I do have this question. When they say Wisconsin courts have interpreted this phrase to encompass acts, the court isn't exactly saying that's exclusive. Or this court isn't saying it's exclusive, right? If Wisconsin courts have interpreted the phrase to encompass acts that corrupt public morals or outrage the sense of public decency, it doesn't necessarily imply that they haven't interpreted the phrase to encompass other things. It encompasses those things, but only those things? This court isn't saying that. The court isn't saying only these things. It isn't saying Wisconsin courts have interpreted this phrase to only encompass acts that corrupt public morals or outrage the public decency. So did the Wisconsin courts say that and only that, or is that one thing they said? A time. Kind of a big difference between those two things. Defendants argue that even if his belief was ultimately mistaken, the sergeant has a reasonable basis to believe there's probable cause to arrest under the catch-all of disorderly conduct language because he'd been informed that the Instagram post was causing significant disturbance, anxiety, fear, concern, and even panic among citizens, which I mentioned. Defendant's probable cause argument dramatically understates the probable cause analysis for disorderly conduct. If accepted, and this is, again, like another straw man or part where the court kind of loses the page for me. If accepted, defendant's position would largely gut the First Amendment for freedom of speech, allowing police officers free hand to wrongfully arrest anyone engaging in protected speech so long as the offending officer could point to a possible disturbance or perceived anxiety among those who oppose the speech. Yeah, okay, court, you're kind of overreading that a lot. If we accept that they have the power to arrest Amyiah because of the actual panic, well, that would mean they could arrest for anything, anytime. I mean, no, that doesn't necessarily flow. That isn't a necessary premise, right? If we concluded they could arrest for anything, anytime, it would necessarily flow that we could arrest for this. But because we can arrest for this, it doesn't imply the other way around. The court is being a bit disingenuous here. This is a parade of horribles, which might in some sense be prudent, but it is a bit off point in this particular analysis. Accordingly, the Wisconsin Supreme Court has held that speech that falls within the protection of the First Amendment may not be punished as disorderly conduct. And I'll tell you what, at the end of the stream, for those of you who want to stay along, I know there was a request to review this case. So I'll tell you what, we'll review the case. How about that? We will review In re Douglas from the Wisconsin Supreme Court. I will dig it up and we will review it together and we will see if it says anything like this, because it feels like it can't possibly say that simple. So we'll review that too. How nice. Defendants offer no answer to this precedent, which removes any basis for probable cause. Yeah. We'll see, I guess, when we read the Wisconsin Supreme Court decision, but I'm a little doubtful. Because Amyiah's social media posts were protected speech, Sergeant Klump could not have reasonably had probable cause to arrest her family. The probable cause defense fails as a matter of law. I'm not so sure about that one. Excuse me while I have some water. Okay. Where were we? Defendants fare no better with their invocation of qualified immunity. It is well established that qualified immunity does not apply for requested declaratory relief. And they cite relevant authority. Is Wisconsin in the 7th Circuit? I thought they were in the 6th for some reason. Hold on, let me get my circuit map. Oh, Wisconsin is in the 7th. Okay, noted. I thought it was in the 6th, but it's in the 7th. Okay, cool. So that is binding authority on this court, so fair enough. That solves that problem real easily. Let's see, where was I? The proposed injunctive relief is too broad and unnecessary. Yeah, we can kind of skip this entire analysis because Amyiah's own lawyer in the hearing said, if you give us declaratory relief, we'll be solved. And so, of course, the court's going to jump at that. If that's going to give you full satisfaction, we can kind of skip all that analysis. And so, conclusion, the First Amendment is not a game setting for the government to toggle on or off, which I'm not sure about that analogy, but okay. It applies in times of tranquility and times of strife. While defendants in this case may believe their actions served a greater good, that belief cannot insulate them. Demanding a 16-year-old remove protected speech from Instagram is First Amendment violation. Declaratory judgment is granted. Okay. All right, so let's do this. Let's pull this Wisconsin Supreme Court case that apparently says, according to this court, accordingly, the Wisconsin court has held that speech that falls within the protection of the First Amendment may not be punished as disorderly conduct. Okay, we're gonna read that and see how applicable it is to this situation. So we're gonna pull this In re Douglas, unless of course you'd like me to do something else with my time, but that sounds fun. So give me a second to pull that up. I need the State Court of Wisconsin from the Supreme Court, please. Done. And I need In re Douglas. D. Okay. Wisconsin second, 204. Okay. Yeah, Wisconsin second, 204. Wisconsin second, 204. Okay, it's also called, I'm not sure where they call it in re. In the citation, it's called State v. Douglas. Oh, it's in the interest of Douglas. Okay, I understand why. Okay, fine, whatever. Let's print that off into PDF form, and then we can talk about it together. And what it does or does not have to teach us on this matter. I got it. All right, so let's see. All right, cool. Now I'll pull it over here. Great. I need to resize this window a little. No, that'll work. Okay, so in re Douglas, 243, Wisconsin 2nd, 204 from 2001. Let's see what this case has to teach us. This is a review of a Court of Appeals decision, unpublished, in which affirmed a judgment from the circuit court, which is the district court, the trial court, in Oconto County. The circuit court found the content of an 8th grade creative writing assignment authored by the petitioner, a minor, constituted a threat against the English teacher. Based on this finding, the court adjudicated Douglas delinquent for violating the disorderly conduct statute. Okay. Douglas now petitions this court to reverse this Court of Appeals decision, which affirms his delinquency. In doing so, he presents 2 issues for review. Can the disorderly conduct be construed to criminalize purely written speech, even if the speech does not cause a disturbance, which, is different from Amyiah's fact pattern? If so, is the speech protected by the First Amendment, thus barring the state from prosecuting him? We conclude that purely written speech, even written speech that fails to cause an actual disturbance, can constitute disorderly conduct. Written speech can constitute disorderly conduct, even if there's no disruption. However, because the speech falls within the protections of the First Amendment, state nonetheless is barred from prosecuting. Accordingly, we reverse. Okay. This case arises from the events that occurred while Douglas was an 8th grade student at public school. In 1998, Douglas's English teacher, who commonly refers to herself as Mrs. C, gave Douglas a creative writing assignment. Mrs. C instructed Douglas to begin writing a story, which would later be passed on to 3 other students, each adding to Douglas's work. But other than entitling the assignment top secret, Mrs. C provided no limit regarding the topic of which they were to write. Rather than beginning his assignment, Douglas visited with some friends and disrupted the class. Therefore, Mrs. C sent Douglas into the hall to complete the assignment. At the end of the period, Douglas returned to class and handed in his work. A few minutes later, Mrs. C read what Douglas had written. There once lived an old ugly woman, her name was Mrs. C, that stood for crab. She was a mean old woman that would beat children senseless. I guess that's why she became a teacher. Well, one day she kicked a student out of class and he didn't like it. That student was named Dick. The next morning, Dick came to class and in his coat he concealed a machete. These are all badly spelled. When the teacher told him to shut up, he whipped it out and cut her head off. When the sub came 2 days later, she needed a paper clip, so she opened the door. Ah, she screamed as she found Mrs. Head in the drawer. Okay, so first of all, this 8th grader needs some spelling lessons. So there's that. Second of all, off the top of my head, that kind of sounds like a threat. Like, it's obviously describing the situation at point. I mean, we all get that, right? And saying, I'm going to conceal a machete and chop your head off. Sounds like a threat. So we'll see what the court has to say, I guess. But yeah, okay, I understand the concern. Okay. Mrs. C believed the story to be a threat if she disciplined Douglas again. I understand why. Douglas intended to harm her. As a result, she became frightened. After dismissing Douglas, she notified the assistant principal. Upon learning of the incident and observing that Mrs. C was upset, the assistant principal called Douglas into his office. Douglas apologized for the story, saying he did not intend it to be interpreted as a threat. But it totally is. The assistant principal then imposed Douglas an in-school suspension. After Douglas served his suspension, the school readmitted him to class, albeit with a different teacher. However, in 1998, the police filed a delinquency petition, alleging that by submitting a death threat, he'd engage in abusive conduct under circumstances in which the conduct tends to cause a disturbance, thus violating the statute. Well, yeah, I mean, that seems to be kind of right on point, so I'm interested to see where the Supreme Court's going with this. In 1999, the Circuit Court held a fact-find hearing regarding the delinquency. After hearing testimony from Douglas, Mrs. C, the assistant principal, and an employee of Human Services, the court explained that pursuant to the law, the petitioner had the burden to prove two elements. The juvenile engaged in abusive conduct, which can either be physical acts or language, and the conduct occurred under circumstances that tend to cause a disturbance. Applying these standards to the facts, the court found Douglas has communicated a direct threat to Mrs. C. The threat, the court continued, constituted abusive conduct unprotected by the First Amendment. I mean, it's violent, to quote the other statute. Like, when we're talking about, disorderly conduct and we're talking about violent conduct, I mean, this is kind of violent conduct. It's under a different statute, but yeah. Okay. Second, the court found that Douglas' conduct provoked the disturbance. It caused Mrs. C to become upset. Based on these findings, the court ruled that they were guilty of disorderly conduct. Accordingly, they ruled they be placed on formal supervision for a year. Douglas raises two arguments. First, he argues the delinquency adjudication, based on the contents of his school creative writing assignment, violates his First Amendment right to freedom of speech. Yeah. Second, he contends that even if such an adjudication does not violate it criminalizes conduct and therefore cannot be construed to constitute purely written speech. Yeah. For these reasons, Douglas requested the Court of Appeals reverse. The Court of Appeals does not. All right, so what does the Supreme Court do? What does the Supreme Court of Wisconsin have to say? We first review whether the disorderly conduct statute can be construed to criminalize purely written speech, even if speech does not cause a disturbance. This presents an issue of statutory interpretation. It sure does. And then we have the statute that we've read before. Whoever in a public or private place is engaged in violent, abusive, this would be abusive, and I'm probably less than violent, but abusive, indecent, profane, boisterous, unreasonably loud, or otherwise disorderly conduct, which leads to provoking a disturbance, is guilty of a Class B misdemeanor. To prosecute a violation, the state has the burden to prove two elements. First, it must prove the defendant engaged in violent, abusive, indecent, profane, boisterous, unreasonably loud, or similar disorderly conduct. Second, it must prove the defendant's conduct occurred under circumstances where such conduct tends to cause or provoke a disturbance. Under both elements, it's a combination of conduct and circumstance that's crucial for analyzing it. That makes sense. Douglas first argues that conduct, as used in the statute, does not include speech unless such speech is intertwined with physical action. In support of his arguments, Douglas cites RAV, a very, very famous case dealing with noise amplification in parks. For the general rule that governments cannot regulate the content of speech. He further explains that Wisconsin courts have adhered to the rule. On one hand, Wisconsin courts consistently have struck down legislation that criminalizes speech protected by the First Amendment. Yeah. On the other hand, there's no published opinion in which the court has upheld a conviction under this for speech alone. In light of this precedent, Douglas argues the state has recognized it's constitutionally barred from convicting persons based solely on the content of speech. We reject this argument. To be sure, the First Amendment generally prevents government from prescribing speech because of disapproval of ideas. However, it's well understood the right of freedom of speech is not absolute. Some categories of speech are likely to cause a clear and present danger under a serious substantive evil that arises far beyond a public inconvenience, annoyance, or unrest. These categories include fighting words, speech that incites others to emit lawless action, obscenity, libel and defamatory speech, and true threats. As the Supreme Court has noted, such speech constitutes no essential part of the expression of an idea. Despite the verbal character, this speech essentially is a non-speech element of communication. In that sense, it's analogous to a noisy sound truck. Each is a mode of speech. Both can be used to convey an idea, but neither has itself a claim upon the First Amendment. Yeah, a sound truck can be regulated because it's noisy, not because of the ideas. Speech can regulate, consistent with First Amendment, these unprotected categories of speech. The right to regulate, however, does not give the state unbridled discretion. To survive constitutional scrutiny, a state must narrowly tailor any regulation that limits the content of the unprotected speech unaccompanied by conduct. On one hand, the regulation must not be overbroad. The United States Supreme Court has addressed this issue, in which it reviewed a Georgia statute that provides in pertinent part any person who, without provocation, use to or of another, and in his presence. What the hell is this word? We get to do a vocab lookup. Hold on.
Opprobrious.
Opprobrious. Expressing scorn or criticism. Wow. Okay. Scurrilous. Okay. Opprobrious. Okay, court. It is his presence opprobrious words or abusive language tending to cause breach of peace shall be guilty of a misdemeanor. That's kind of broad. I think we can agree on that much. After examining cases in which the statute has been applied, the court concluded the statute had not been limited to application to criminalize only unprotected speech. In some circumstances, the statute had been applied to criminalize protected speech that merely offended. The court explained, the constitutional guarantees of freedom of speech forbid the state to punish the use of words or language not narrowly within limited classes of speech. Even as to those classes, however, because the line between speech unconditionally guaranteed and the speech which may be legitimately be regulated, suppressed, or even punished is finally drawn. In every case, the power to regulate must not be exercised so as to, obtaining a permissible end, unduly infringe the protections. In other words, the statute must be carefully drawn or authoritatively construed to punish only unprotected speech and not be susceptible of application to protected expression. Applying the standard, the court struck down the statute as being unconstitutionally overbroad. In doing so, the court made clear the state regulation of speech may not be so broad as to criminalize not only unprotected speech, but speech that enjoys the protection of the First Amendment. And the statute as it's written, especially if you read and other stuff in that light, would be there. If you read it more open-endedly, you might have a problem. On the other hand, the regulation must not be underbroad. The United States Supreme Court addresses concern in RAV. In this case, the court analyzed an ordinance which banned people from placing on public property a symbol, object, applications, characteristic, or graffiti, including, but not limited to, a burning cross or Nazi swastika, one of who knows, or has reasonable grounds to know, arises anger, alarm, or resentment on the basis of race, creed, color, religion, or gender. Yeah, so I think I got RAV mixed up with some other case, so ignore what I said about the sound thing, because that seems to be wrong. I forget which case that was then. I know I've made that mistake before, too, but yeah, ignore that from before. The Minnesota ordinance banned people from placing on public or private property a symbol, object, appellation, not limited to burning cross or Nazi swastika, one has reasonable grounds to know, arouses anger, alarm, or resentment on the basis of race, creed, color, religion, or gender. As construed by the Minnesota Supreme Court, this ordinance applies only to fighting words, one category of unprotected speech. However, the ordinance only prohibits one particular type of fighting words that insult or provoke violence on the basis of race, color, creed, religion, or gender. In analyzing the regulation, the court explained that although the government may regulate consistent with the First Amendment, certain categories of speech, it may not regulate such speech based on hostility or favoritism towards underlying message expressed. Because the St. Paul ordinance discriminated against fighting words expressing a particular viewpoint, and viewpoint discrimination, as we all know, is super bad, the court held the ordinance was unconstitutionally underbroad. I understand. This makes sense. Thus, as illustrated by this holding, a state may not generally regulate so narrowly as to criminalize only particular viewpoints. Yeah, viewpoint discrimination is a no-go. Turning to the regulation issue in the case, it's clear that if the section applied to speech alone, would not suffer it from infirmities the Supreme Court has described. is not overbroad. As this court has repeatedly held, the language of the disorderly conduct statute is not so broad that sanctions may apply to conduct protected by the Constitution. Which, sure. Is this speech protected by the Constitution? If that's where we're ultimately going with this, I'd be surprised. That would surprise me. But we'll get there. I guess we'll get there. So, thus, the sanctions cannot be applied directly to speech protected by the First Amendment. Second, the section is not underbroad. It prohibits all unprotected speech that's likely to cause substantial intrusions which offend the normal sensibilities of average persons, the average ordinary person of normal prudence, or which constitutes significantly abusive or distributing demeanor in the eyes of a reasonable person. It does not prescribe certain viewpoints, which is bad, within the category while leaving related viewpoints outside the scope. For these reasons, we conclude the First Amendment does not inherently bar the state from applying the statute to unprotected speech, even if the unprotected speech is purely written. So, yeah, protected speech is protected, unprotected speech is unprotected, even if written. So, okay, I mean, yeah, that's fine. Although today this court has not reviewed a case in which defendant was convicted under the statute based solely on the content of speech, we've construed disorderly conduct to prescribe some categories of constitutionally unprotected speech. This court has examined the scope of the 1947 version of the statute to determine whether the statute could be construed to punish a union leader for inciting striking union members to resist a police officer. In arguing the case, the union leader contended the statute only reached language. It could not be stretched to criminal acts alone. We reject that argument, explaining the words of the statute must be read in the disjunctive. That is, that they may make an offense to use such language or engage in disorderly conduct, tending to result in that. Thus, we conclude the statute could have been interpreted to apply to disorderly physical acts. However, in doing so, we made clear the statute could also apply to speech unaccompanied by physical acts. This court has made a similar interpretation. This court in Lane was whether a trial court properly denied the defendant police officer motion for a directed verdict in a false imprisonment tort case, where the officer arrested the plaintiff for violating disorderly conduct based on the plaintiff's statement that he thought the officer was an SOB, but was suggesting where the officer had provoked the statement. Yeah, that's not going to fly, I hope. In coming to our conclusion the trial court had properly denied the motion, we explained the disorderly conduct statute at issue was similar import to the revision of a different statute entitled disorderly conduct, which makes it a misdemeanor for a person to engage in abusive, indecent, or profane conduct in a public or private place. The underlying reason for the disorderly conduct statutes and ordinance prescribing abusive language is that such language tends to provoke retaliatory conduct on the part of a person who's addressing it, and that amounts to breach of the peace. Calling another person an SOB under charged circumstances might well constitute abusive language and likely to have that result. Okay, well, apparently contempt of cop is a thing, so don't call a cop an SOB, I guess. This interpretation comports with language and purpose of the statute to root out conduct that unreasonably disrupts the peace. To be certain, like the laws at issue, is not a blanket prescription of certain words. By contrast, is recognition that the fact that in some circumstances, words carry with them not prescribable non-speech elements. For example, unreasonably loud speech, even if the words themselves are protected, carries with it a non-speech element of excessive volume. Similarly, abusive speech carries with it the non-speech element of express or implied threat or challenge to fight. These non-speech elements, consistent with the prescribed conduct, as these elements that consistent with the First Amendment can be punished. This is a long wind-up to yes, we can punish the kid. I mean, pursuant to this standing, we conclude the state is not barred from convicting Douglas for the content of his story merely because the story consists of purely written speech. However, the state still has the burden to prove Douglas' speech is constitutionally unprotected abusive conduct within their reach. Okay. Douglas contends his speech, even if otherwise punishable threat, did not occur under circumstances which the speech would cause or provoke a disturbance. Douglas explains the court has defined disorderly conduct as conduct which has tendency to menace, disrupt, or destroy the public order. Does any of that sound a little bit familiar with the Amyiah case at all? Pursuant to this definition, Douglas argues, requires more than conduct that causes personal discomfort. Applying this reasoning to the facts at hand, Douglas contends that because there's no evidence that his story caused anything more than personal discomfort, he cannot be punished for disorderly conduct. Douglas is correct insofar as he indicates that not all conduct which causes personal discomfort falls within the ambit. Yeah, this court has held as much. The law does not imply that all conduct which tends to annoy is disorderly conduct. Only such conduct as unreasonably offenses the sense of decency or propriety is included. Which, I'm going to chop off your head kind of seems like that. The statute does not punish a person for conduct which might offend some hypercritical individual. The design of disorderly conduct statute is to prescribe substantial intrusions which offend normal sensibilities of an average person or which constitute significantly abusive or disturbing demeanor in the eyes of a reasonable person. This, we agree, requires more than offensive speech or behavior. However, we cannot agree with Douglas' contention that threatening a public school teacher while in school is not the type of conduct that causes a disturbance. Right? I mean, I'm going to bring a machete, I'm going to chop off your head, is a little bit more than mere annoyance. I think school violence is all too prevalent. Cites. Our children consequently must often learn in an environment of fear in which education suffers. Violence in schools makes teaching difficult and inhibits student learning. In addition, unsafe school environments expose students who may have already been at risk for school failures to other failure-related, such as physical and emotional harm. For these reasons, the public has become increasingly concerned with serious student threats of violence. With this in mind, we cannot imagine how a student threatening a teacher could not be deemed conduct that tends to menace, disrupt, or destroy the public order. Yeah. And again, with respect to Amyiah's post, is it conduct that would menace, disrupt, or destroy the public order? I mean, I think we're beyond mere annoyance. It makes no difference under the statute whether, as Douglas asserts, alleged disorderly conduct actually causes a disturbance. Rather, conduct only needs to be the type that tends to disturb. Simply because a listener exhibits fortitude in the face of the threat is no reason to allow the threat to go unpunished. Accordingly, we conclude the fact that Douglas' story did not cause an actual disturbance, which, is kind of debatable, actually, is irrelevant to the present inquiry. It's enough that Douglas conveyed a story under circumstances which would tend to cause or provoke a disturbance. Okay. We next consider whether Douglas' story is protected by the First Amendment, thus falling outside the bounds of conduct of the statute. The Circuit Court ruled the story is not the type of activity that's allowed under the First Amendment. However, the courts support that rulings only with conclusory finding. There's no question the story is a direct threat to teachers. Assuming arguendo, the Circuit Court correctly found that the story is a threat, this finding did not warrant the court to make the logical jump to conclude the story necessarily constitutes a true threat unprotected by the First Amendment. Really? Really? Okay. Contrary to the Court of Appeals, for the purpose of a First Amendment analysis, a threat is very different than a true threat. Threat is a nebulous term that indicates anything from an expression of intent to inflict pain, injury, evil, or punishment to any generalized menace. Under such a broad definition, threats include protected and unprotected speech. Thus, states cannot enact laws prohibiting all threats without infringing on some speech protected by the First Amendment. By contrast, a true threat is a constitutional term of art used to describe a specific category of unprotected speech. This category, although often inclusive of acts that fall within the broader definition of threat, does not include protected speech, which necessarily must be true. Therefore, states may, consistent with the First Amendment, prohibit all true threats. How is this not a true threat? This should be entertaining. Wisconsin prohibits true threats that occur under circumstances which such conduct tends to cause or provoke a disturbance by means of prohibition or abusive conduct. Abusive conduct is conduct that, at least in part, is injurious, improper, hurtful, offensive, or reproachful. True threats clearly fall within the scope of this. Consequently, if Douglas' story constitutes a true threat, which I think, the state could properly prosecute him, we must therefore determine whether or not it is a true threat. How is this not a true threat? The question of whether a particular conduct constitutes a true threat is an issue of fact, typically left to the finder of fact. However, the question, if the conduct is unconstitutionally protected, it may be protected as a matter of law. If the court says this is unquestionably protected by the First Amendment, I'm going to lose it a little bit. I'm going to bring a machete and chop off your head. Okay. As this court explained, a true threat is a statement that in light of all the circumstances, a speaker would reasonably foresee that a listener would reasonably interpret as a serious expression of purported proportion to inflict harm, as distinguished from hyperbole, jest, innocuous talk, expression of particular views, or other similarly protected speech. It is not necessary that the speaker have the ability to carry out the threat. Okay. Should he be able to reasonably perceive a listener would reasonably pursue it as an actual real threat, as opposed to hyperbole? I mean, I think so. Yeah. Some factors the courts and juries should consider when applying this test include, but not limited to, how the recipient and others reacted to the alleged threat, whether the threat was conditional, whether the threat was communicated directly to the victim, which it was, whether the maker of the threat had made similar statements to the victim on other occasions, and whether the victim had reason to believe the maker of the threat had propensity to engage in violence. In the present case, Douglas argues his story was not a true threat because it did not express an unequivocal, unconditional, and specific expression of intention immediately to inflict injury. Really, though? He contends his story is fictional, third-party creative writing assignment, which would receive full protection under the First Amendment. Conversely, the state contends that Douglas' story is a true threat. According to state arguments, the first two paragraphs of the story closely parallel the events that had taken immediately before the assignment. Yeah. A teacher named Mrs. C removes a male student from class. The next two paragraphs, the state contends, conveys the threat. When the teacher disciplines the student the following day, the student uses a machete to cut off their head. The state's case makes some sense to me. Further, the state attributes great weight to the fact that Douglas handed the story directly to Mrs. C, the subject of the threats, rather than, for example, just reading it in jest to the friends. In light of these circumstances, the state argues that Douglas' threat to Mrs. C is direct and clear. If she disciplines him again, he intends to injure. Thus, it's a true threat. The state's argument is kind of ringing more true to me on this one, to be honest. I'm gonna bring a machete and cut off your head. Applying this test above, while we believe the story is crude and repugnant, we nonetheless must reject the state's argument. Okay, Wisconsin Supreme Court. To be sure, Mrs. C testified that Douglas' story threatened and frightened her. Further, Douglas conveyed the messages directly to Miss C. However, there's no evidence that Douglas had threatened Miss C in the past, or Miss C believed Douglas had a propensity to engage in violence. Moreover, Douglas wrote the story pursuant to Miss C's request in the context of creative writing. In such class, teachers and students alike should be expected to allow more creative license, be it for better or in this case worse than other circumstances. Had Douglas penned the same story in a math class, for example, where such a tale would likely be grossly outside the scope of his assigned work, we would have a different case before us. Okay, so let me get this straight. Because it was... So if this had been in a math class and he had written this screed and handed it to the math teacher, it would be different than handing it as part of a creative writing assignment. The court seems dangerously close to implying that true threats aren't true threats when they're in a creative writing assignment. I'm not sure creative writing assignment gives you license to make true threats. The Wisconsin Supreme Court seems to disagree with me right now, but okay. But in the context of the creative writing class, Douglas' story does not amount to a true threat. First, the story does not contain any language directly addressed from Douglas to Mrs. C. The court is an idiot. Rather, it's written in the third person with no mention of Douglas. Wow, really? Really, Supreme Court of Wisconsin? You fell for that? Really? You fell for that? Oh, this story doesn't talk about Douglas. It could be talking about anybody. Really? You couldn't see beyond the words on the page to, figure out what was going on? We have no clue Douglas is involved. Really, Wisconsin Supreme Court? Okay. I mean, you are master of your state's law, so rock on. Second, Douglas's story contains hyperbole and attempts at jest. It jokes that Miss C is short for crab. In addition, it suggests Miss C is so mean she beats children and speculates that for this reason she became a teacher. Third, explained to Douglas that in this particular assignment he was merely to begin writing a story that other children would complete. Thus, Douglas could expect another student to end his grisly tale as a dream or otherwise imagined event. Under these specific circumstances protected by the First Amendment, I'm less convinced than the Wisconsin Supreme Court on that one. I'm not 100% buying it. But you, of course, can come to your own conclusions on this one. We do not doubt the story was a result of Douglas's anger at having been removed. Further, we sympathize with Miss C. She was justified in feeling offended. And we firmly believe the school took appropriate action against Douglas. Which, incidentally, doesn't follow, by the way. We firmly believe the school took disciplinary action against Douglas. That doesn't follow. You know why it doesn't follow? If it were truly protected First Amendment speech, presumably the school couldn't discipline him either. The school, after all, is a governmental authority. So, the court's saying, oh, it was okay for the school to discipline him for this purely protected speech? Really? That seems in contrast to Tinker, for example. However, a 13-year-old boy's impetuous writings do not necessarily fall from First Amendment protection due to their offensive nature. As the Supreme Court has explained, to many, the immediate consequence of the First Amendment freedom may often appear to be only verbal tumult, discord, and even offensive utterance. These are, however, within established limits, in truth, necessary side effects of the broader enduring values which the process of open debate permits us to achieve. We cannot lose sight of the fact, in what otherwise might seem a trifling and annoying instance of individual distaste, abuse of the privilege, these fundamental society's values are surely impacted. With that in mind, we conclude Douglas's story, although we find it to be offensive and distasteful, unquestionably, is protected by the First Amendment. Our feelings of offense and distaste do not allow us to set aside the Constitution. Okay. Okay, so now the court's about to explain why my comment about Tinker was wrong. Okay. Well, let's try that. By no means should schools interpret this as undermining their authority to utilize their internal disciplinary procedures to punish speech such as Douglas's story. Although the First Amendment prohibits law enforcement officials from prosecuting protected speech, it does not necessarily follow that schools may not discipline their students for such speech. To be sure, students do not shed their rights at the schoolhouse gates. Thus, like law enforcement officials, educators may not punish students merely for expressing unpopular viewpoints. However, the First Amendment must be applied in light of special characteristics of school. Unlike other instrumentalities of the state, schools are entrusted with a unique role to mold our children into responsible and wise adults. The educational mission is not limited to academics. Rather, it entitles many other responsibilities: advisor, friend, counselor, and all too often parent's substitute. Pursuant to these responsibilities, educators must inculcate our children the habits and manners of civility. While the fundamental values of habits and manners of civility essential to democratic society must, of course, include tolerance of divergent views, even where the views may be unpopular, they also include society's countervailing interest in teaching our children the boundaries of socially acceptable methods of discourse. For this reason, in school context, students may limit or discipline conduct, which for any reason, whether it stems from time, place, or type of behavior, materially disrupts classwork or involves substantial disorder or infringes the rights of others. But didn't you just go through a whole analysis saying that this wasn't disruptive? Under the circumstances in this case, we hold the school had more than enough reason to discipline Douglas for the content of the story. Although the story is not a true threat, it is offensive. Crass insult to Mrs. C. Schools needs to not tolerate this type of assault to the sensibilities of educators of students, or students. The First Amendment does not compel teachers, parents, and elected school officials to surrender control of the American public school system to public school students. Okay, I'm not 100% convinced on that one. In sum, we re-emphasize that we share the public concern regarding threats to school violence. Society not need to tolerate true threats. Such speech, even if purely written, can and should be prosecuted under disorderly conduct. However, under particular facts of this case, the speech at issue fails to rise to the level of a true threat. Douglas's story, though repugnant and insulting, falls within the protection of First Amendment. As such, it may not be punished as disorderly conduct. However, we also recognize that it's highly appropriate for a function of schools to prohibit the use of vulgar and offensive terms in public discourse. Although we hold the story as not a true threat and therefore cannot be punished, we nonetheless believe the school properly disciplined Douglas. There feels like a little contradiction here. This case reinforces our belief that while some student conduct may warrant punishment, school discipline generally should remain the prerogative of schools, not our juvenile justice system. Accordingly, we reverse. And there's a concurrence. Is there a dissent on this by any chance? There's another concurrence. Concurrence. There is a dissent. Yeah, there is a dissent. I was just curious what the vote was in this. Just seeing if it would tell me the vote somewhere. Apparently, no, it doesn't want me to do that. Oh well. So, I don't know how informative that situation was to Amyiah. But, yeah, if it's First Amendment protected, it can't be punished as disorderly conduct. Yeah. So, yeah. But the police probably still had probable cause because of the actual ensuing panic. But it would prevent the charge from going forward by the court, I think. So, I'm not sure what that analysis does for any of us, but that's where we are. All right, let's read and see if you had any questions or comments along the way. Joe's Med said, the coffee shop example, though, would more squarely fall within enumerated parts of disorderly conduct because unreasonably loud. Fair. Good point, well spotted. Joe's Med said, I view disorderly conduct in relevant part more as a time, place, manner restriction, rather than you can't say this dangerous thing, period. Fair. Joe's Med said, there's a difference between shouting fire in a crowd theater versus writing letters saying there's a fire in a crowd theater. Well, maybe. Azeroth said, so if the student was speaking and someone has a panic attack, should the cops be allowed to cut off the offender's tongue for causing panic? No, Azeroth, please don't go. Okay, Azeroth, you're taking this and you're taking it to the extreme end of the page, which is a bit, yeah. Joe's Med said, I don't see a reasonable cop reading content-based restriction into time, place, manner. If she posted, I don't have COVID, there'd be no threats. Matt said he sent me the case, which I was able to find myself. Matt said, could it be unpublished matter at all? I don't understand the question. Joe's Med says, so I guess it can be content-based, but based on this Wisconsin Supreme Court, I still don't think it applies here. That's a reasonable conclusion, Joe's. Matthew says, I think the court basically is looking at the writing assignment as fictional and such not true threat. Santiago Vera says, is there any chance you can review the Hobby Lobby SC case so we can get ready for the Texas abortion case reached the Supreme Court? I'm not sure how informative Hobby Lobby would be on the Texas Supreme Court case, but maybe. Maybe. So, yeah, I think I'm not 100% sold. The court might be right. The district court might be right here on the 3-step analysis. They might be right, although I'm not 100% sold on step 1. And even if we conclude it is, so yeah, even if we conclude it is, but which it may well be, have to ponder it a little bit, but it might well be. We know from the U.S. Supreme Court case that we cannot file a retaliatory First Amendment claim if the police have probable cause. So the question is, did the police have probable cause? And, her ultimate ability to be punished, is one thing. But the police, when they arrest you, aren't strictly speaking punishing you. Obviously, that's what a court does, right? So, yeah, did the police have probable cause? Well, it was in fact cause. It's true that the and other stuff isn't like any of the other things, but to the officer at the beat seeing an actual disruption, it's probably reasonable to read it that way. So I'm still not sold from the court on the probable cause analysis. I think excuse me. I think they're being a little bit dismissive of what was going on at the time. So that's sort of what I think the conclusion is. So there's no money in this case. The request for nominal damages was denied. There's no attorney's fees provision in a declaratory judgment case. So, but that, of course, doesn't preclude the state from appealing if they want to. The state has standing. The declaratory judgment is, after all, saying they did something wrong, and they could still appeal if they want to. So I don't know whether or not they will appeal, but I think if I had to put money on it, I think that the Court of Appeals would likely reverse. They might very well agree with the court on Section 1, but I don't see how they can agree on the probable cause analysis. Matt says, I think under probable cause they can probably get there. However, in my opinion, they forced her to speak, which is outside what probable cause would protect. How did they force her to speak? Donald says, can you please invite Barnes on as a guest to talk about Rittenhouse before the court can limit what he says? I don't know that Barnes would be interested in appearing on my channel. How did the police force her to speak? What did they force her to say? You mean by forcing her to delete something? That's different, though. Like, the ability of the police to silence you is different than compelled speech. So it's a slightly different analysis. Yeah, Azeroth, they shut her up and made her delete a speech. That's not compelled speech. That's different. Like, if you're the compelled speech is where they're making you say something. It's not where they force you to take down something. Matt says, taking down the post would seem forced speech to me. That was some cases where I've seen that matters. Well, it was forced. It was compelled, but it wasn't forced speech because they didn't force her to say anything. So I think, unless you're aware of some specific cases, it seems off. Taking down the post is compelled speech. I don't think that's true. That, if you accept the underlying premise, that this is in fact disorderly conduct, then forcing her to stop this disorderly conduct would be lawful, right? If you accept the underlying premise that this is disorderly conduct, forcing her to discontinue the disorderly conduct would be lawful, speech or otherwise. That's not compelled speech. Compelled speech would be put up a post saying that you were lying, or put up a post saying something. That's different. Santiago says, thanks for the redo. I watched both and you were more calm and seemed to enjoy this one more. Yeah, and I got the law wrong. I batched it pretty hard. I was talking about 1983. I was talking about 1988. I was talking about clearly established. I was talking about a whole bunch of things. I don't know what to tell you. I'm just so used to seeing these as 1983 cases. I don't know. The 8 times the district court said declaratory judgment, I guess I missed them all. And then it was funny. It's funny because I watched when I finished the stream, I immediately watch it back, right? And I noticed the error right away. The first time I said it, I'm like, wait a second, that's not right. So I don't know, it's interesting. I don't know what that says. It probably says, at least in part, that my intention is split a lot of different ways. Because I'm reading the case, I'm trying to do camera, trying to look at my levels, make sure they're okay. Sometimes trying to look at chat, right? Maybe opening a browser to find another case. So at any given time I'm streaming, I might be doing 3 or 4 different times. So maybe it's a split of my attention problem, but it was interesting because I watched that video immediately, and within 5 minutes I realized I made a mistake. I'm like, oh. And then I posted a pin thing there saying I screwed this up. And then I thought to myself, you know what? This is actually a pretty big screw up, so I'm going to have to just take that one down and try again. Because we try to give good legal education over here, not, me talking completely out my ass. At Brandeis and Whitney versus California, thinking about enforced silence. Yeah, the remedy for bad speech is more speech, not enforced or not compelled silence or enforced silence. Yeah, this is true. Yeah, but they weren't. Yeah, but they weren't talking about. What was Whitney about? Wasn't it about? Yes, it was about. It was about a woman who was promoting the Communist Party, I believe, and somehow was illegal, and the Supreme Court said that's illegal. Yeah, but even Brandeis concurred, right? He said, but this is okay, even Brandeis, but he had some nice stuff in there otherwise. Law Nerds clips. Okay. Is CVNT a fighting word for both Karen and Kevin, or only Karen because of gender? I don't know. It would depend on the person. Yeah. Is mistake of law, the cop misunderstood the statute, different from mistake of fact for the purpose of arguable probable cause? No, I don't think so, but I think it's probably okay either way, right? If the facts are not what the officer believes them to be, but he has a reason that they're reasonable for him to believe them, right? So he can believe things that aren't true, is if they're reasonable for him to believe them. And that's okay, because that would just be a mistake, right? If he has mistaken beliefs. The court even said as much in my case, right? So even if the probable cause was ultimately mistaken. So if his facts are wrong, it doesn't nullify the probable cause. If his mistake of law is and I don't think would nullify the underlying arrest. Yeah. I don't think it would nullify the underlying arrest, especially where the interpretation is reasonable, as it appears to be here, at least in practice. So, yeah. Matt says, wouldn't it be great if all crimes had to be clearly established to be charged? Cute. But that's, not how it works. But yeah, noted. Okay. So we'll see if this is appealed or not. I don't know what the appetite for the government to appeal is. Maybe they won't, because it's no skin off their back, and maybe they'll just let it go. But it'll be interesting to see if they appeal or not, for whatever pride there is, and whether or not the Court of Appeals will agree with them or not. But at least for this court's reasoning, I found some flaws in the analysis, which we pointed out that somewhat undercut its conclusions, at least in part. If you accept that she didn't cause the panic, there's no probable cause. If they believe that at the time, sure. Yeah, if the cop believed that she didn't cause the panic, then yes, there would not be a probable cause. Right? So if the cop had in fact believed that she was not responsible, yeah, that's right. The reason I think Hobby Lobby is relevant is because the minority in Hobby Lobby is probably going to be a majority. Maybe. Fair enough. Well, I'm going to sign off. I hope you've enjoyed this discussion, round 2, where we try to get it right. If you've enjoyed this stream, please remember to give it a like. If you're not subscribed, please subscribe. And did you know for 99 cents you can become an uncivilian? It's true. If you look by some of the people's names, they have little icons of scales of justice next to their name. And they could be different colors. The different colors represent how long they've been members of the channel. The scales of justice represent that they are members of the channel. You can be like them too. You also can have a cool scale of justice and be super cool. All you have to do is hit the join button or click the link that the bot periodically tells you about. For mere 99 cents, lowest possible on YouTube, you too can become an uncivilian and be one of the cool kids. It's awesome. Until later, my friends, I hope all is well. Cheers and goodbye.